आज से करीब 150 साल पहले असम की एक विधवा औरत ने पूरे बंगाली भद्रलोक पुरुषवादी समाज को हिलाकर रख दिया था. This is the story of how an impure widow from Assam shook the very foundation of upper class morality and patriarchy system prevailing in the society both in Bengal and in Assam. Her name was Keri Kolitani. The name Keri is unusual in Assam for women, but she was born with squint eyes, hence the name Keri. Keri in Assamese means squint eyes. If that naming discrimination was not enough, what happened next to her will blow your mind. Her story became one of the most significant and controversial legal battles in the late 19th century.
The claim is upheld. Judgment is entered accordingly.
Impossible, she won? How can that be? Against him, the magistrate...
Her case was referred years later by many judges in many cases involving the rights of widow and women in India. Recently, we could see how our beloved Garima Garg was trolled when she wore lipstick and makeup after the demise of her husband, Assam's heartthrob Zubin Garg. Someone commented on how well done her eyebrows were. This one commented on why she is wearing heels. Somebody commented on her colorful dress. Of course, many came out in support of her. So, are widows not allowed to wear lipsticks or wear makeup? Or even if they wear colorful clothes, the dress should not attract lots of attention? Seriously? It makes one wonder, has our mentality really changed at all even after 150 years? The famous case of Keri Kolitani of Assam, society called her impure, fallen, unchaste and apavitra vidhava, as was decided by the court and society back then in year 1880. It was so significant and landmark judgment that the case went to Privy Council of London. The case of unchaste widow Keri Kolitani versus Moniram Kalita nearly shook the Hindu Bhadralok Society of Bengal and Assam at that time. In legal language, it came to be referred to as the Unchastity case. The story begins in Municipal Court of Sibsagar district of Assam. Keri Kolitani was married to one blacksmith named Gendhela Kolita. The couple had no child but were happily married. Gendhela passed away after few years because of jaundice. Keri Kolitani became a young widow at the tender age of 25 years. After her husband passed away, she inherited her husband's property as per Hindu laws. However, after few years, she fell in love with another man from her village. Both could not marry because Keri Kolitani was a widow and widows were not allowed to remarry during those times. However, after few years, Keri Kolitani gave birth to a child from that person. This created much tension in her village. The family members and neighbors outcasted Keri Kolitani as she has made herself dirty and impure. The British administration got involved when the issue of inheritance arose involving the dead husband's property. Keri Kolitani's cousin brother-in-law, Moniram Kalita, filed a case in the municipal court in Sibsagar claiming his brother's property. He said, Keri lost the ownership of her husband's property since she has made herself impure and unchaste, going against the society norms. As per Hindu law, she cannot remarry, nor she can be in relationship with anyone. The duty of a widow is to wear white sari, wear no makeup and express grief and sorrow for the rest of her life. A widow remains the eternal property of her dead husband's family. The Bengali Bhadralok of year 1880 Calcutta took great interest in the case. This landmark legal battle of Keri Kolitani drew huge attention in Bengal. For Bengali Bhadralok, it was a case of Obaidha Prem, Obaidha Samporka, unthinkable adultery and immorality. Kolkata's newspapers filled with debates about unchaste widows and moral decay. The appeal was admitted in Calcutta High Court on account of the importance of the questions submitted for determination. Following questions were raised before the court. Number 1. Was Keri Kolitani an impure or dirty widow or choritrahin apavitra vidhava under the Hindu law? Reason, because she as a widow had an affair with another man long after her husband passed away. Number 2. If she was indeed an unchaste widow, should her husband's property be taken away from her? This was a very tricky situation for the British judges. It was not easy to reach a decision given how conservative the Hindu society was at that time. The entire city of Kolkata was rife with discussion about how women's liberty was being encouraged by the British, leading to social degradation and total disintegration. A number of Sanskrit scholars, experts on ancient Hindu law and Shastras were summoned to the court and their opinions were sought in the case. Those who were requested to opine included famous Pandits such as Mahesh Chandra Nyairatna, Bharat Chandra Shiromani and Pandit Taranath Bhattacharya. Ishwar Chandra Vidyasagar was also invited to express his opinion, but he could not make it to the court owing to his ill health. Of course, all of these experts decided against the widow. They quoted extensively from ancient texts like Jimyud Vahan Katyavan and Daibhaga, where a widow's duty was specified. A widow without a son was given the right to perform certain rituals like Shraddh for her deceased husband, and in lieu, she would be provided a frugal vegetarian meal to continue her services towards her departed husband. She had no right to enjoy any worldly pleasures or take in a romantic partner. The full bench of Calcutta High Court consisted of the Chief Justice and 9 other judges. The judges were totally divided in their opinions. Renowned Justice Dwarkanath Mitter remarked, "Indeed, according to true theory of the Hindu law, a widow is nothing more than a trustee for the soul of her deceased husband. Since Keri has dirtiest herself, she no longer can keep her dead husband's property." One judge, Mr. Justice Glover, drew clear distinction between a widow and a son. Only sons down to the 3rd generation could do the most service for a deceased person by performing Shraddh. Hence, sons are the first in the line to claim property of their dead father. The status of a widow comes next only after the sons. However, a widow without a son can only perform Shraddh so long as she continues to be pure and chaste. Ultimately, in the end, the decision went in favor of Keri Kolitani, because at the time when she inherited the property, she was a pure and chaste woman, not a fallen woman.
Having heard the arguments and examined the evidence, this court finds for the petitioner, Mrs. Barua. The claim is upheld. Judgment is entered accordingly.
Impossible, she won? How can that be? Against him, the magistrate.
The citizens of Bengal were so outraged and became so restless that they went to the extent of raising public funds to send the case to the Privy Council in Britain. However, lawyers of both the sides agreed on one count, that Keri Kolitani was an unchaste, fallen, dirty and impure widow, and the derogatory term was branded on her. This case forced elite Bengal to reopen its scriptures, to re-examine what purity meant, and to question who defied morality. Yet, even a century and a half later, when we still police how widows dress or how much they smile, are we really different? Keri Kolitani's story is not about an Assamese widow. It's a story of every woman who dared to live when the society told her to die.